Thank you all again for joining me. I'm Anita Koumriqian. I'm an attorney and partner here at Alcorn Immigration Law. And today we are going to be discussing marriage-based immigration options. So just a little bit about us, the Alcorn story, and what we do. We overcome borders, expand opportunity, and connect the world by practicing compassionate, cutting edge, and rigorous immigration law in the service and betterment of humanity. What we do, we pride ourselves on operating under our four main core values: expertise, compassion, integrity. There's one more, and it's escaping me, but it's an important one, I promise you. But we do all of that, and it is with great pride that we are able to serve the immigrant population with a 95% success rate. This is me, Anita Koumriqian. Again, I am a partner here, proud Santa Clara and UCLA alum. My expertise and what I love to do the most is family-based immigration. And I thoroughly enjoy it. I love being able to help people, to work with people day in and day out. I also have experience practicing family law. So that kind of gives me a leg up when it comes to helping people with their family-based immigration options. But I'm an immigrant myself. That's why I'm in the area of immigration law. I'm a proud American. I'm raised Armenian. Ethnically, I'm 100% Armenian. And I was born in Iraq. I moved to the United States when I was 4 years old. Here's a copy of mine and my sister's green cards. Here we are, considered resident aliens. I'm at the bottom. But this is so personal to me. So in addition, of course, to being compassionate and understanding and empathetic with my clients, I do it because I was there. Yeah, granted, sure, I got my green card when I was younger, but I witnessed my family struggle. I struggled myself too, just going through the process. But I'm grateful to be where I am. This is our incredible team. You will be helped by these wonderful smiling faces. And everyone is fantastic. Everybody is either an immigrant themselves, married to an immigrant, a child of an immigrant. So again, it really makes the work that we do all the more personal, and it helps us love our jobs more. This is our network. We have alliances with top universities. We are certified woman-owned business, which is awesome. And we love working with some of the fastest growing startups and just companies in the Bay Area, in the United States, and all throughout the world. That's what's so cool about being an immigration attorney. People ask me, well, do I have to be in Mountain View in order for you to be able to be my attorney? Absolutely not. I have clients literally all around the world, and we can support them all. What do you need to know about immigration? I always like to answer this with everything, right? That's why you're here. I won't be able to tell you everything that you need to know about immigration today, but I will do my best to answer questions that you have. I'll make it, again, through the slide deck, and at the very end, go ahead and ask those questions throughout, and I'll go through and answer them for you. So what's the typical pathway for status here in the United States? So there's two main typical pathways, right? You either enter the United States with a visa, a temporary visa, whether it's sometimes it can be a visitor's visa, sometimes it's an H-1B visa, a student visa, something of that nature. And then that visa can then be potentially a foundation for you to then get your green card, and then for you to be able to apply for citizenship. Now, there's other people, especially in the family-based arena, where they can actually enter the United States right off of the bat using their as a green card holder. So instead of having a non-immigrant visa, they would get an immigrant visa stamped into their passport. And with that, they enter the United States as a green card holder right off of the bat, with the ability to work right away, travel internationally, all of that fun stuff. So when it comes to figuring out which typical pathway is best for you individually to go down your immigration pathway, this is a huge part of it, and we'll discuss it some more in a bit as well. Immigration during COVID. Man, has it been a fun year? It will almost be the full 1 year anniversary of the world being in essentially a shutdown. I believe March 17th was the date. But immigration during COVID, it was really rough. At one point, I felt like I had turned into a journalist. All of those newsletters that a lot of you guys get, we personally write those, and we do our best to make sure that you are up to date on all of the latest and greatest news with immigration. And there was a lot of changes during COVID. In addition, of course, to a lot of changes, there was just primarily delays with biometrics, with interviews, and just people being able to get their what they need done with immigration. What USCIS is doing now is doing their best to make it through the backlog as best they can. And that backlog is growing daily. So right now, USCIS is operating, from what we understand, at about a 20%, 30% capacity, and they're not going to go up to normal capacity until, from what I understand, until a lot, if not all, of the officers are fully vaccinated, so that the staff of these local offices feel comfortable putting their officers into interviews with applicants. So what a lot of offices now are doing is offering telephonic appearances for the attorneys to attend their interviews, their client interviews with their clients over the phone, instead of being another additional body in the office at the local USCIS offices. So that's huge, and we're hoping that will carry out. For how long? I have no idea. Green card bans at the consulate. Yep, unfortunately, green cards are still banned. We thought that with the expired proclamation, that the proclamations that expired at the end of last year, that it would not be ongoing. Unfortunately, green cards are still banned at the consulate unless you fall under one of the many exceptions under the proclamation, one of which is marriage to a United States citizen, or a couple of different exceptions as well. So green card bans at the consulate for family-based applications. For some, it's worse than others, but there's ways around it. And then expedited appointments. Some visa interviews can be expedited. Some green card interviews can be expedited if absolute need be. So if you feel like you're in a pinch and you need a visa interview or whatever it may be, reach out to us. Let us see what we can do to support you so that you can get what you need done. So we're here today, right, to discuss various marriage-based options. A fiance visa is one of two options that I weigh back and forth with people who reach out to me and say, well, I'm in a relationship and we're engaged. We don't know whether we want to go down the fiance visa option or the green card option. And with that, it gives us, me being the potential attorney, you being the potential client, it gives us a lot of flexibility to be able to kind of slow down and see, should I tell you, should I advise you, do not get married, let's go down the fiance pathway? Or should I say, go out and get married tomorrow if you can, so that we can get this show on the road and get you into the United States? So that's what we'll do. What we'll be doing today is going through the two different options. So the K-1 fiance visa, you have to be engaged to a United States citizen. I wrote this on here on this slide twice because it's pretty important. A green card holder cannot petition for somebody, cannot petition for their fiance to enter the United States. You have to be a United States citizen in order to pursue this pathway. So obviously, one huge criteria is being married to a United States, engaged to a United States citizen. Do not get married. If you are married, you cannot qualify under this visa category. So careful. And some people say, well, what if I just do the religious ceremony and it's not the legal marriage and I enter the United States on a fiance visa? It can be a little bit tricky because sometimes an officer can have the authority and the ability to say, no, you're actually married. And sure, maybe it's not It's not what you intended that to be, but you are married, so you do not qualify under the fiance visa category. So go get a marriage-based green card. So just be careful. But essentially what it is you file a K-1 fiance visa when you are separated. So let's say I'm in the United States and my fiance lives in Armenia. And I want to petition for my fiance to get his green card eventually. But first I would have to file that K-1 fiance visa while my fiance is abroad. We go through that process. It's called an I-129F. You essentially are filing that to prove I'm a United States citizen. I have met in person with my fiance at least one time, preferably 2 times. And here's proof that we are in this good faith relationship. So that's the initial process. And then the step 2 of the fiance visa process is my fiance will go to the visa interview in the home country where my fiance is currently residing. So again, let's say he's living in Armenia. So he goes to that interview and then he enters the United States on a single use visa, on that K-1 fiance visa. You enter the United States one time and one time only with that visa. You enter, and then from there you have 90 days to get married. Yes, now you have a very short window of time to get legally married in the United States. And that 90-day time to get married is absolutely critical, or else you will not be qualified to move on to the green card portion of the application, or there will be additional complexities in the case. So it's important and critical to get married within those 90 days. Can you get an extension for those 90 days? No, you can't. So get married within those 90 days. It doesn't have to be that big hoopla wedding where there's 500 people that are invited or at the wedding. It can be a smaller thing. Just to make sure that you take it seriously, get married, enjoy the wedding, because at the end of the day, it is your legal marriage. So you get married, and then once you are married in the United States with that K-1 fiance visa within those 90 days, you go ahead and you go through the green card application process. So you are in the United States with a valid visa, then you apply for an adjustment of status based off of marriage from there, which we'll talk about in a second as well. And again, only available to United States citizen. That is critical. How do you go through the process? Oh, I already went through this process. So you file that I-129F petition, and then the foreign national fiance enters the United States using that K-1 fiance visa. You get married within those 90 days, and then you file for the adjustment of status application. So that's the K-1 fiance visa, and then the other 2 options that we're going to discuss next are marriage-based options. So with these ones, you have to be married. So with these are the 2 options again. So adjustment of status where you're in the United States versus consular processing. What is adjustment of status? It is adjusting your status when you're in the United States in valid visa status already, and you're adjusting your status from whatever status you have to green card. So again, with the K-1 fiance visa, if I'm in the United States and I entered on a K-1, got married within those 90 days, I will then be filing an adjustment of status application to adjust my status from K-1 visa holder to green card holder. And you go through the entire process from there, filing it with the USCIS office here in the United States. And ultimately, you file the application, you file several applications and all supporting documents. And ultimately, your case will be scheduled for an interview here in the United States at the local field office. And that is dictated based off of where you're currently residing. And that's where you will be scheduled for interview. Now, consular processing is that thing that I mentioned several minutes ago now, where you enter the United States immediately as a green card holder. So you file the application based off of marriage. So again, going back to the idea of me filing, I'm a United States citizen and I want to petition for my husband who's living in Armenia. Now, ultimately, I start the process here in the United States, but ultimately my husband will get his green card, his immigrant visa at the consulate in Armenia or whatever country he is residing in at that time. So that's the consular processing portion. So adjustment of status, who can adjust their status? If you're in the United States and valid visa status, you can adjust your status. So K1 fiance visa, H1B, F1 student can be a little bit tricky. J1 can be a little bit tricky. But you have to be in the United States in a long-standing status. Oftentimes people ask me, well, can I enter the United States with a visitor's visa? That's a valid visa that I'm entering in the United States with. Can I enter using a B2 visa, a visitor's visa, and then adjust my status from there? No, you cannot, because technically that's breaking the law, right? So when you're entering the United States as a B2 visitor, you're ultimately telling that Customs and Border Patrol officer, hey officer, here I am, let me into this country for 6 months max, or maybe for 3 months, 90 days if I'm entering using ESTA. And once my trip is over, I'm going to go back to my home country. I have these strong ties in my home country that I'm not going to come into the United States, and I'm not going to file a green card application. No way. I just am here temporarily. So that's the intent when somebody is entering the United States as a B2 visitor. Now, if you enter the United States as a B2 visitor and then you file a green card application thereafter, the USCIS will scratch their heads and they'll say, didn't you just enter the United States with a visitor's visa and tell me that you're going to be going back to your home country after this? You lied, and you lied in order to get an immigration benefit of a B2 visitor's visa. So therefore, because you lied, that's misrepresentation, fraud, I'm going to deny your green card. That is a nightmare. You don't want that to happen. So ultimately, when I enter the United States as a visitor, can I file an adjustment of status application based off of marriage after? The answer is no. But if you find yourself in that arena, reach out to me, let's chat. How do you get a green card through adjustment of status? So you can see the chart on the right-hand side of my screen. It walks through what the timeline looks like of filing an adjustment of status application. So you file the application. Once you file the application, they send you receipt notices. Then they send you notices to get your fingerprints taken. Then you're given a work permit and international travel authorization. So with this work permit and travel authorization, you can work for any employer in the United States and you can travel internationally while the green card application is pending. And until you get that work authorization and international travel authorization, you cannot work in the US or travel internationally. Some exceptions apply to that. For example, if you have an H1B visa, you can still work and you can travel internationally without having any issues on your green card application. And there's just complexities. But in some cases, let's say you're in the United States on an E2 visa, if you were to travel before you get that travel authorization, your green card application will be considered abandoned. So be careful, be mindful when you're doing anything immigration related, ask questions. I think that's one of the biggest takeaways that I hope you get out of today's conversation. No question is silly, no question is ridiculous. Ask those questions because it's better safe than sorry. Nobody's gonna get annoyed with you for any silly questions that you may have. So ask your questions away, set up a time to speak with me or anybody on my team, and we'd be happy to support you. So once you get your work authorization, then it's the waiting game for your case to be scheduled for interview. Your case, again, will be scheduled for interview at the local office, at which time an officer will ask you questions about your relationship, as well as ask questions just to confirm that you are eligible to get your green card. So in terms of relationship, they'll want to know, how did you meet? Where did you meet? Who was at your wedding? And questions like that. They don't often ask you questions much more than that. Of course, unless the officer absolutely feels that they don't really understand. I've had interviews before where the officer gave my clients a piece of paper and said, draw me what your bedroom looks like. So there's some complexities, or sometimes there's difficult interviews. Officers will not ask you questions about intimacy. I don't think that they want to hear them. I don't think that they will ask you those questions. So if you have any concerns about any of that, again, ask away. But what comes next? So after the interview, assuming everything at that interview goes well, you will receive your green card in the mail after that. Individuals will either get a 2-year conditional green card or a 10-year permanent green card. And that is all dependent on your, on how long you've been married. Those who have their green cards approved and issued before their 2-year wedding anniversary will be given a 2-year conditional green card. Those who are approved and issued after their 2-year anniversary get a full 10-year green card. If you only get a 2-year conditional green card, then that means that at the 2-year anniversary of having your green card, so let's say I get my green card today, my green card expires in 2 years from today. So 2 years, 2 years from now, I would have to file an additional application with USCIS to let them know, hey, I'm still here. My partner and I are married. We're still so in love. Here's these additional documents to prove to you that we're still in this good faith relationship. Or, oh man, things didn't work out. We tried so hard to make it work, but we had to go our separate ways. But when we first did get married, officer, let me tell you, it was entered in good faith. I loved my partner so much and it just didn't work out. So again, with that, there's ways around it. But that's the conditional green card process. Now consular processing. So with consular processing, similar to adjustment of status in that you have to be married. And so with these, marriage-based green cards can be for US citizens as well as green card holders. Unlike the K-1 fiance visa, which I didn't mention during the adjustment of status part, a green card holder can petition for their spouse to get their green card. I'll talk about that a little bit more in a second, but both of these processes, again, so with consular processing, it starts off with an application saying, I'm a US citizen, I'm a green card holder, and I want to petition for my spouse to get his green card at the consulate in his home country. You start off that process, you start off with filing an I-130 petition. Once that I-130 petition is approved, it gets forwarded on to another entity called the National Visa Center. We provide them with additional information and documents, and then ultimately my spouse is scheduled for interview at the consulate. Again, let's say in Armenia. Do I have to go to that interview in Armenia? I'm the US citizen. Do I have to go to the interview in Armenia with my spouse? No, you don't. Your spouse goes to that interview by themselves. Do I have to go to the interview if it's locally in the United States? Yes, for that one you do have to go if you're locally in the United States. But the consular processing, it's just the applicant spouse who has to go to this interview. We'll be asking similar questions again. When did you meet? How did you meet? When did you get married? Who's at the wedding? And just questions about the relationship, and then asking you questions about whether or not you qualified to get your green card. Have you ever been arrested? Have you ever had any issues with immigration, denied visas, anything of that nature? You ask those questions, and then ultimately, hopefully you get your green card approved. And again, with that green card, it's an immigrant visa. They don't give you the green card right away. They stamp an immigrant visa in your passport. You have 6 months to use that visa to enter the United States. Once you enter the United States, boom, you're a green card holder. You pay one additional nominal fee, and then they will mail you the green card in your actual physical green card in the mail. Again, it could be a 2-year green card or a 10-year green card, depending on how soon you get the green card after you're married. And then one additional thing that I want to mention, it may be in the slides in a little bit, but what's the difference between a green card holder spouse filing or a US citizen spouse filing? So as a United States citizen, if I'm petitioning for my spouse, I qualify to petition for my spouse as an immediate relative, and they are not subject to the visa bulletin. What is the visa bulletin, Anita? A visa bulletin is what dictates how many people from each specific category from sometimes specific countries can enter the United States. So back when immigration laws were initially created, there were quota systems that said from this country, there's this amount of people that can enter using this category. So with all of that, that's how the visa bulletin and priority dates, that's why those words get thrown around. So as a US citizen, my immediate relative, which is my spouse, would not be subject to the visa bulletin. But as a green card holder, if I'm a green card holder, my spouse would fall under the F2A visa bulletin category. Historically, that visa bulletin category was backlogged by about 2 to 2.5 years. Now it's been, I think, about a year and a half now. I think August of 2019. There's been no backlog with the F2A visa category, which is incredible. So that's one additional thing that you would have to consider or think about when going through the process. Sometimes people say, man, I'm so close to becoming a United States citizen. Do I have to file under the F2A category, or how do I go into that other category? A little bit complicated. You can file, or you can start the process as a green card holder, but then you would eventually become a US citizen and you can upgrade the petition from there. So all things are possible. Well, not all things with immigration, but a lot of things are possible with immigration. So fiance visa versus marriage-based. So how do you pick between the two? Do I want to petition for my fiance, or should we get married and we file a green card application? It's a lot of weighing the pros and cons and figuring out what is most important to you. So here I write, ultimately, it is about the goals that you have individually in your lives, as well as a couple. So with a K1 fiance visa versus a marriage-based pathway, the consular processing, you have to figure out what your goals are. Are your goals to be in the United States faster? You can't be separated anymore. You don't want to do that long distance relationship anymore. If that's your primary goal, then let's seriously consider a fiance visa for you. But if that's not your goal, and your goal is to enter the United States with the permission to work right away, then we would actually have to consider the spousal route instead. So when you file a K1 fiance visa, you're entering the United States as a green card holder. And then once you get married, then you file that adjustment of status application. Now, if you were following what I was saying earlier and what you with that timeline that was shown up, it takes about 7 to 8 months after you file the application during non-COVID times for somebody to get their work authorization through the marriage-based options. Now, let's do the math, right? You have 90 days to get married, and from there, 7 to 8 months after you file an application to get your work authorization, that means that if somebody's entering the United States with a fiance visa, they can't work or travel internationally for about a year. So if somebody says, Anita, we can't be separated anymore, then I'll say, is it okay if you don't work? Is it okay if you don't travel? And they say yes and yes. And I'll say, okay, cool. Let's get started on a K1 fiance visa. But if they say, no, I can't not work for a year, what are you talking about? Or no, I have to maintain my ability to travel internationally because I have mom and dad back home and they're ill or they're old, and I need to be able to maintain the ability to travel internationally and visit them. Then I'll say, okay, then the best pathway for you then is to go down the marriage-based consular processing route. Because ultimately what the difference between the two options are is with the K1 fiance visa, you're using that as a pathway to enter the United States so that you can legally get married and then file a green card application. It's a longer process if you go down the K1 fiance visa. It's also a more expensive process if you go down the K1 fiance visa. But none of that matters if your goal is just to be together faster. So that's an option for you. Now, the marriage-based option it feels like it's longer. The marriage-based consular processing route, for the most part, pre-COVID, takes about 1.5 years, about 18 months. While it takes 18 months, what you have to remember is you're entering the United States, you're stepping foot in the United States as a lawful permanent resident, as a green card holder. You're not entering the United States and then having to go through then start the green card pathway. You're already done with that green card pathway. So again, those are the two different routes that you have to kind of figure out what makes more sense for me. And again, ultimately it's about your goals individually and as a couple. If my goal as a couple, if me and my fiance said, you know, our couple goal is to be together so that we can spend the rest of our lives together, cool, that's our couple goal. But if my fiance says, but babe, I can't not work in the United States, I can't have that. So then I'll say, okay, well, we will have to go down the marriage-based route. So how to pick, it's a hard decision, and you have to figure it out a bit. Have those difficult conversations with your loved one, and whatever decision you ultimately do decide to make, it's going to be perfect for you. But ask the questions again, and sometimes it's difficult to decide which one is better. Schedule a time. Let's figure out. Let me help you weigh your pros and cons for you. So the February visa bulletin, again, this is for the people that fall under that F2A category. So here, spouses of a lawful permanent resident. And here, C, we have shows the C, meaning it is current. And historically, it wasn't often current. So this is pretty exciting that it's been current for so long. Breaking news, immigration reform bill. This is pretty exciting. So last week, February the 18th, the US Citizenship Act of 2021 was introduced to the House of Representatives. And this is so exciting because it's happy, it's positive, it's good news for immigrants, it's good news for immigration attorneys, and it's good news just for the United States, for everybody. So what it is it's a huge part of everything that Biden campaigned and told us about. So it's his commitment to us to modernize, to make better the immigration system. What it does is it offers an 8-year pathway for citizenship for those who are undocumented, which is phenomenal. It allows millions of family-based immigrants to enter the United States. Specifically, it allows people who have approved I-130 petitions to enter the United States and stay in the United States while they're waiting for their green cards. This is huge because that means that I don't have to tell my spouses who are filing for filing the marriage-based consular processing route. I don't have to say, cool, this first part has been approved, but you still have to wait about a year until we finish step 2 and step 3 of the process. Now, once there's an approved I-130, get into the United States and be with your spouse and then finish that green card process together in the US. So we'll see what that brings to us. And then a huge part of it is, again, it's keeping families together. So it would allow beneficiaries with approved I-130s to enter the United States while they're waiting. It would eliminate the 3-year and the 10-year bars. This is humongous. Since the 1990s, the ideas or the concepts of the 3-year and 10-year bars were introduced to the world of immigration. And what these meant was if somebody accrues a certain number of days of unlawful presence in the United States, meaning you're in the United States without legal status or permission to be here, every single day of unlawful presence will lead you towards the 3-year bar or the 10-year bar. And once you hit, so for the 3-year bar, it's 180 days. Under 365 days, if you step foot outside of the United States, you trigger the 3-year bar where you cannot enter the United States for 3 years. For the 10-year bar, it's 1 year and more. If you trigger the 10-year bar against you, you're stuck outside of the United States for 10 years. So it would eliminate the 3-year and 10-year bars, which is awesome. It would make it easier for spouses and children to join their families who are already in the United States. It would speed up the process and increase the number of green cards that are available and the ability to recapture unused green cards. So a huge part of the reason why the F2A visa category is, from what we understand, current and has been current for a while is because people are not using the opportunity to use that category to enter the United States. So we would recapture those green cards, that quota number, and get more people in the United States. It would increase the number of green cards in the diversity lottery program. So again, there's a very strict quota on the diversity lottery program, and it's actually pretty difficult to get your green card through the diversity lottery program. So it will increase that. And it will stop using the word alien and change it to non-citizens. So way back in the beginning of the presentation, my green card picture that said resident alien would have actually read resident non-citizen. So pretty cool. And then that pathway to citizenship that we discussed. So it would provide a pathway for dreamers, TPS holder, immigrant farm workers, and just undocumented individuals to get their green card, to get their citizenship actually. And this is, it notes down the requirements of somebody getting their green card. So you have to be physically present in the United States on or before January 1st of 2021, which is a lot of people. And it's pretty exciting, and they'll waive the presence requirements and all. So it's a big deal. So another, in addition to that, so dreamers, TPS holders, and those farm workers would be able to apply for green cards immediately. So they would be able to get their green cards, and then once they have their green cards, they would be eligible to get their US citizenship after 3 years. So it's pretty cool. So we're hopeful with that. We'll see what happens, but we're hopeful. And then continuing on the pathway to citizenship, certain undocumented individuals would be eligible to apply for temporary legal status. And then once they pass their background checks and have paid their taxes, they'll be able to apply to get their green cards after 5 years. And then after 3 years of having their green cards, then they can apply for US citizenship. So it's pretty phenomenal. That is my presentation for today. Let us know what we can do to help you, to support you. We have all kinds of social media. Follow us on social media. We have LinkedIn, Twitter, Instagram, Facebook, and we have a really cool podcast. We have a new episode on our podcast every Tuesday. I'm a guest on it often. We have some pretty cool speakers that are on the show as well. So follow us, like, subscribe, do whatever else that you can do on social medias to follow us. And now let me go through and find those questions to answer them for you. So I'm seeing an outline forum that there's a backlog with K-1 visas, considering this also, sorry, I'm trying to understand the question. So the backlog with K-1 fiancé visas right now during COVID is that K-1 fiancé visas are not being adjudicated or issued at the borders. It all really depends on where you are in the process. If you are just now starting the K-1 fiancé visa process, it may be worthwhile to start the K-1 fiancé visa process now, because by the time that the cases will be scheduled for interview, we're hopeful that the world will be back to normal and cases will be scheduled for interview again. Can I promise you that? I can't promise you anything. But which one is faster, a K-1 fiancé visa or the marriage-based CR1 route, consular processing? Pre-COVID, I would say K-1 fiancé will get you in the United States faster. The green card process ultimately is longer because you're doing two processes essentially. You're doing two processes. So you're doing a consular processing route for your K-1, and then you're entering the United States, getting married, and then filing a green card application. So you have a longer immigrant journey, but you're in the United States together with your loved one faster. So which one is faster? Which one is more advisable? It all really depends. Again, it goes back down to that question of which one, what makes more sense for you? What is your goal? Is your goal to be in the US faster? Then do the K-1 fiancé visa. Again, pre-COVID. Is your goal to be able to enter the United States and work right away? Then you have to go the marriage-based consular processing route. I'm a citizen currently married to a non-citizen, and the only thing that has held us from proceeding with the process is figuring out how much money we pay. Also, how long can the process take? So each process that you go down pricing is all dependent on the pathway that you go down and the complexities of your case. If money and time is the only thing that is holding you back, then let's schedule a call, reach out to me. Let's figure out what your options are. And then once we figure out what your ideal pathway is and figuring out the legal complexities of your case, then I'd be able to give you a quote on the process. And then how long can the process take? Again, it all depends on a couple of things now, actually. One is COVID, how bad are the backlogs and what is going on right now with COVID? And then two is what pathway we decide to go down. So for the most part, if you're filing an adjustment of status in the adjustment of status marriage-based process here now in the United States, it's probably going to take you anywhere from 2 to 3 years to get your green card based off of the COVID delays. So that could make it more difficult for somebody to decide to get started now. But what I tell people is the line is not going to get any shorter. Get in line now so that you don't have to think, oh man, I wish I filed sooner. So definitely consider it. Where is it best to send package? Should it just be forwarded to Texas USCIS office? I don't know what package you are referring to, but every single application has to be sent based off of where you're living and where you're filing the application from. All filing addresses can be found on the USCIS website based off of, again, where you're living. So don't just mail something to a local office. Make sure that you're sending it to the correct location. Oftentimes they get sent to lock boxes or service centers. So there's a lot of different things going on with USCIS or just the Department of Homeland Security. So just be careful and be mindful of where you're mailing packages, because you don't want it to get sent to the wrong place and then ultimately rejected. Can I work on a K-1 visa? No, that's the issue and that's the concern, right? So that's why some people have to make the decision of filing coming into the United States with a K-1 visa versus the marriage-based route. With a K-1 visa, you cannot work in the United States until you're given that work authorization. So by virtue of entering the United States as a K-1 fiancé visa holder, you're not given the permission to work. You have to wait, you have to get work authorization, and then you can work, which is why some people will say, I can't go down that option or that pathway because I need to be able to work. Next question. I got married last September in the US. Congratulations. My husband is a green card holder and lives in New York. If I go there now on my tourist visa, can we submit our green card application after 90 days? I'm currently a master's student in Europe. I have a lease, blah, blah, blah. Let me read that so I don't give up too much of your information. I would recommend that we schedule a consultation so that we can discuss your questions further, because you cannot enter the United States. Again, this goes back to what I was saying a little bit earlier, entering the United States as a visa holder and then getting married, or not getting married, but entering the United States as a visitor's visa holder and then filing a green card application is risky and is in violation of the law. So you don't want to be caught. Not caught, you don't want caught, I guess. You don't want it to be found out that you entered the United States with non-immigrant intent and then filed a green card application, because that could be considered misrepresentation. So don't do that. Don't break the law. But let's schedule a call. Let's talk and consider what your other options are. How long does it take on average to get a permit to work and a permit to travel? What are those forms we need to file to request those? So pre-COVID times, it was taking about 6 to 8 months to get your work authorization and international travel authorization, while when you file that initial adjustment of status application. Now during COVID, it's unfortunately taking a little bit longer. because it's taking longer for the local USCIS offices to get people's biometrics. Without their biometrics, you cannot be issued the work authorization and travel authorization. So pre-COVID, it was taking about 6 to 8 months. Now, honestly, it's been taking closer to the 8 to 10 month mark, and don't hold me to that estimate, but it's been more difficult. If you find yourself waiting to get your biometrics and you're waiting to get your work authorization, you could consider doing an expedite request, along with everybody else that's doing an expedite request to get your biometrics captured so you can file or can finally get that work authorization and travel authorization. But it's a difficult time right now, in USCIS and just the Department of Homeland Security entirely. So if I have a B1, B2 visa, there's no way to go for an adjustment of status. The 90-day is not real in practice. It is not advisable to file a adjustment of status application based off of marriage when you enter the United States on a B1, B2 visa. The 90-day rule that you are referring to is a thing. But again, ethically and legally, when you enter the United States on a B1, B2 visa, and then you file thereafter an adjustment of status application, you are taking the risk of the officer determining that you have misrepresented yourself at the border when you first entered the United States to gain entry into the United States. And by that, they can deny your green card application in its entirety. So you got to be careful with that. Again, if you have any specific questions related to this, you can schedule a consultation, ask those questions in private, and with confidentiality, so that you can make sure that you're getting the support and the answers that you need. Embassies are still closed, and we still don't know when they're going to resume and how much new processes will be delayed. Is there another option for me as the spouse of a green card holder? So as the spouse of a green card holder, you can pursue a marriage-based consular processing option. You do fall under the exemption of the proclamations. So you can still file to get your green card you can still file to get your green card. Based off of marriage, and you shouldn't run into delays with that. But again, let's schedule some time. I know I keep saying that, but I don't want to say too much by reading the question and divulging too much information. So let's schedule a time so that we can speak privately to answer your questions. What does the reform mean for marriage-based green cards? Does it speed up the process for someone married to a US-born citizen? Yes, that's exactly what we're hoping that the reform bill means. So what everything that's going on, so obviously the bill, the reform bill, what they're trying to do is not in effect, and we'll actually see it go into place. And what I always like to do is once it's law, that's when I will believe it, that's when I'll start practicing it, obviously. But it should, what it is supposed to do is streamline more of the processes. It's supposed to clear up backlogs and delays. And unfortunately, COVID has created some of the worst delays that we have ever seen in the history of immigration. It's never been like this before. So with the reform, we're hopeful that the delays will quickly come to an end. Don't hold me to that, but that's what we're hoping to see. Also, could it backtrack us in the process if we're married and he's already in the United States? I wonder if that's the beginning of, or a second part of somebody's question. If you wrote that question, please send it to me again, because I think I missed the first part of it. What are some challenges adjusting status from F1 visa to marriage-based green card? So with that, it all depends on when you most recently entered the United States. So be careful with that. If you entered the United States, again, this goes back to when you enter the United States with a non-immigrant visa. If you enter the United States with a non-immigrant visa, you just have to be careful with going from non-immigrant visa, where you're saying at the end of my visa status, I'm going to go back to my home country. From there, we don't want to file a green card application because there's that issue of misrepresentation. So what are some challenges? Challenges can be misrepresentation. Challenges can be, again, that arena. Another challenge is not having work authorization. If you have OPT and your OPT expires and you don't have your work authorization yet through the marriage-based process, that could be a challenge, right? So with that, if you have specific questions, again, I know I keep saying this, schedule a time, let's sit down and chat. If you submit a K-1 but get married, can you shift to a spousal visa instead? That's a very good question. Unfortunately, no, because they're completely separate petitions. So the K-1 fiance visa, the underlying petition that you have to file is called an I-129F. Once that, and that's the underlying petition. For the spousal route, the underlying petition for that is an I-130. So completely two separate forms, complete separate processes. If you file that K-1 and then you get married, it doesn't automatically go to an I-130 petition because it has different questions, different information that you have to provide. So great question, but unfortunately not. What is faster at this moment between adjustment of status and consular processing, given that embassies are closed? Again, depends on if it's a marriage-based route. Honestly, filing consular processing is going to be faster because, again, marriage-based applications are exempt from the proclamations, and the embassies, assuming the embassies are open, which for the most part they should be for some visa categories, they're open and they are serving marriage-based interviews. I've had several marriage-based clients be scheduled for interview and have upcoming interviews coming up as well at the consulates. So quite frankly, and very interestingly enough, consular processing, you will get your green card faster than you would with adjustment of status. How can one get an expedited interview? Been waiting more than 2 years. I'm in the US, she's in Canada. I would recommend that we schedule a call to speak, because if that person is, if it's marriage-based, they should be scheduled for interview, or they should be scheduled for interview coming up. The consular processing route takes a while, and we're not entirely sure when exactly some cases are or are not scheduled for interview. It's really, it's difficult to keep track of all of that. In Canada, I can tell you Canada is one of the consulates that we haven't seen much movement from in terms of marriage-based applications. So hopefully your wait is coming to an end, but we can schedule some time to have a consultation, and maybe there's some options of what we can do to help you. But ultimately, what you can consider is contacting the US consulate or embassy. It's an embassy in Montreal, because that's ultimately where the marriage-based interview would be scheduled, to let them know, hey, I've been waiting for my interview to be scheduled. It's been 2 years, what's going on? And maybe they can give you some additional feedback from there. I think I've answered all of the questions. If I didn't answer your question, let me know, but otherwise we are all done for today. If I didn't answer your question and you would like to schedule some time, again, contact our office. We can schedule a consultation to answer any questions that you have, so that we can speak in private, and you can tell me a little bit more about your personal story, about your life, about your goals, and we'll take it from there. Otherwise, thank you all so much for joining me today. It has been a real pleasure. Please continue to consider us a resource to you individually, to your family, your friends, your coworkers, whoever it is that needs support. Please go ahead and have them reach out to us, or reach out to us ourselves. Thank you so much, and have a wonderful day. Thank you. Bye.